Did you know that without a proper estate plan, your family could lose thousands of dollars in probate costs, and your assets may not actually go where you want them to? My name is Sloane Lambert, and I'm an attorney here at Melone Hatley, PC. And in this video, we're going to talk about some of the dangers of not having a proper estate plan, while also debunking some myths and common misconceptions that come with drafting a will, a trust, or a power of attorney as part of your estate plan. A will in general is a document that actually states where you would like your assets to go upon your passing. In Virginia, there is something called freedom of disposition, which means that your assets can pass to whoever you would like them to. But without telling the state where you would like your assets to go, then your estate will fall to intestacy, which means that there is no will in place or document stating where you would like your assets to go, and they will fall to whoever the state chooses in their order of importance. A trust is also a legal document that states where you would like your assets to go, but in a little bit of a different way. A trust can also be treated as another person, where it can hold property, it can hold finances, and there's a trustee that actually determines and follows through with where those assets go upon your passing. A trust also does not go through probate, so it's a little bit of a quicker process upon passing, as opposed to a will that does go through probate, and you have to wait for the state and your executor to follow through with your wishes. A medical power of attorney, living will, or advance directive, they all operate to have someone speak on your behalf in the event you become incapacitated and cannot speak for yourself when it comes to your medical enforcement. If you are in a position where you're unable to speak to doctors or speak about your end-of-life wishes, someone can actually speak on your behalf following what the document that you have in place says for them to do. A durable power of attorney is very similar in the event where someone can speak on your behalf in the event that you're unable to speak for yourself. But they can speak for more than just medical enforcement. They can speak for real property, finances, and things like that. Now let's debunk some common myths and misconceptions that come with an estate plan. The first is that estate planning is only for the very wealthy. That is a common misconception because regardless of how much you have, regardless of how many properties, how many cars, how much money is in your bank account, you have the right to have your assets go where you want them to. It doesn't matter how much it is. Anything that you have the right to have it go wherever you would like. A will or a trust can actually state where you would like those items to go. Another misconception is that you only have to do this one time. While there are some phrasing in wills that can speak for future occurrences, if you have a child, if you get married, if you end a marriage, those are all things that need to be reflected in your will. A common horror story is that spouses will name each other in their wills and then they will split up. Just because you split up does not mean that your will automatically adjusts itself. If your ex-spouse's name is still listed in your will, then upon your passing, those assets that are listed to go to them will still go to them. That is something that you will need to edit in your will to make sure that that does not happen if that is no longer your wish. Similarly, your children are often listed in your will. But if you have another child and you want to make sure that they also inherit a portion of your estate, you will want to edit your will to add them to it as well. A third misconception is that a will is all that you need as part of your estate plan. While a will might be the most commonly referred to document when it comes to estate planning, there are other crucial documents that serve completely different purposes. For example, as previously mentioned, a medical power of attorney states that someone can advocate on your behalf and follow through with wishes that you've previously chosen in the event you become incapacitated. While thinking about an estate plan might not seem comfortable, this is something that is absolutely crucial to ensure that your wishes and your desires are followed through upon your passing. It really creates ease and a peace of mind when it comes to passing because you know that your assets and your family are taken care of when you're no longer here to do so yourself. Are you confident that your family's future and that your assets are protected and secured? If not, even the smallest of mistakes can lead to financial strain, family stress, and costly disputes. The good news is that a good, proper estate plan can protect you, your family, and your assets from those stressors. In today's videos, we talked about the importance of having a good, proper estate plan and also debunked some of the common myths and misconceptions that come with planning for your estate and your passing. Contact us here at Melone Hatley PC, your partner in divorce and estate planning, to schedule a consultation with one of our experienced estate planning attorneys to make sure that your family's future and your assets are protected.